talk about what's happening with the Trump administration rolling back civil rights. Now, companies these days rarely, if ever, say out loud blacks need not apply, but the reality is we still know discrimination exists. And there's a legal concept called disparate impact. It measures what discrimination is actually happening, whether in employment or housing or school discipline. Now, to force changes in policy by regulatory action or court cases does not require proof of intent to discriminate, just that it is indeed happening. Now, the Washington Post is reporting the Trump administration is planning to stop the use of disparate impact in determining whether there has been discrimination. Now, this obviously is a huge issue to folks in the civil rights community, and so we want to talk to Ajmel Quereshi, Senior Counsel for the NAACP Legal Defense Fund. And so please to tell us, again, for folks who don't understand disparate impact, how dangerous will this be if the Trump administration is successful in doing this?
Thanks so much for having me on today, Mr. Martin. At the end of the day, this is about how victims of racial discrimination have their rights vindicated. Do they have the right to go into court and essentially say, I've been discriminated against, and succeed in their claims? The Trump administration wants to go forward with a method that essentially would require individuals to prove what's called intentional discrimination. That is, the individual would have to come forward with a smoking gun email or recording or a document which essentially would say something along the lines of, I'm not hiring this person because they are black. The reality is that oftentimes those documents don't exist. And if they do, your average victim isn't going to have access to those documents. And the law recognizes that difficulty. And for that reason, the law has provided for a concept called disparate impact, which essentially allows an individual to move forward with their claim if they can show that a policy or practice hurts one group more than another.
And so if you are, so first of all, this goes beyond government. This has an impact on private companies as well, correct?
That's right. So disparate impact is a key concept that exists in various areas of the law. And the two areas in which it's very, very important, it extends beyond the government, specifically employment and housing. In those contexts, the Title VII of the Civil Rights Act, as well as the Fair Housing Act, prohibit actions that have a disparate impact by both the government as well as private individuals and companies.
And so what are you doing, what are others doing in the civil rights community to stop the Trump administration? Any plans to go after them in court?
Absolutely. So I think LDF, since the Supreme Court affirmed in the 1970s that this right to disparate impact existed, as well as in the housing context in 2016 when the Supreme Court affirmed that it existed in the housing context, we've been very active in pushing disparate impact cases and holding employers as well as the government accountable when they have policies or practices that have a negative impact on African Americans as well as other racial groups. I think in direct response to your question, I think the key thing that can be done right now is for Congress to act, for them specifically to affirm that there is a private right of action under Title VI, which provides that the government, as well as local governments that receive funding from the federal government, cannot take actions which also have a disparate impact. And so I think it really, we're going to be pushing the new House, but we certainly encourage the new House to take action on their own to affirm that individuals can go into court to allege violations of Title VI.
Let me ask you this other question here. Of course, the Supreme Court decided today to take up two gerrymandering cases in Maryland and North Carolina. Of course, in Maryland, the Democrats were gerrymandering. In North Carolina, the Republicans. Now, a lower court decision in North Carolina said the gerrymanders districts were done with surgical precision to disenfranchise African Americans. Now, we know the Supreme Court previously punted on the case in Wisconsin. What is going to be the impact, do you believe, on these two cases, them taking this up?
The key question, as you said in this case, is whether or not when a state draws its districts in a way that involves what's called political gerrymandering, that is, they draw their districts in such a way that it is to the benefit of one political party over another, whether or not that violates the law. Time and time again, the court has said that this isn't something they feel like they can address. The question is now, since the court is taking up these two cases, whether or not they're going to wade into the waters and decide there is a standard that can be used to decide this issue. The key thing that's changed since last time is that Justice Kennedy is no longer on the court, and he had indicated in various opinions that there might be a standard that can be used to control these sorts of practices. It's not clear that Justice Kavanaugh, who's replaced Justice Kennedy, feels the same way.
All right, then. We'll certainly be watching these two cases. We appreciate it. Thanks a lot.
Thank you for your time.
All right, folks. You want to support Roland Martin Unfiltered? Be sure to join our Bring the Funk fan club. Every dollar that you give to us supports our daily digital show. There's only one daily digital show out here that keeps it black and keep it real as Roland Martin Unfiltered. Support the Roland Martin Unfiltered daily digital show by going to rolandmartinunfiltered.com. Our goal is to get 20,000 of our fans contributing $50 each for the whole year. You can make this possible. rolandmartinunfiltered.com.